Friends, we welcome you to the Legal Breeze. Today we will be discussing a very important topic known as sedition, law relating to sedition, its constitutional value. The topic can be constitutionality of law relating to sedition. We can divide this topic into the following heads. First, let us deal with the legislative history, why, how it has come, what is the purpose, what is the current law, what is the problem, how to overcome this problem, or what is a remedy to overcome this sedition. First, let us deal with the legislative history. You all know the IPC has been brought into force way back in the 1860s by Lord Macaulay, a wonderful draftman. He has applied his brain along with some other people, learned people, done nicely. In the original IPC, there is nothing called law relating to sedition. How it has come? It has come after almost more than a decade. In the 1870s, it has been inserted in section 124, capital A as 124A. Again, it has been amended in 1898 for a willful purpose to suppress the freedom movement, particularly to target Lokmanya Tilak, Balagangadhara Tilakar. So this is the legislative history. Again, it was kept on amending, added to suppress the freedom fighting in this country. This is the legislative history. And the punishments, yes, originally it was 3 years, but again it has been amended, enhanced for the aforestated purpose, which I have mentioned to you, particularly to suppress the freedom fighters and to crush their throat and to see that they are getting eliminated through an illegal law. Then in the 1950s, the government of India has also made certain amendment. Particularly, it has replaced the transportation because it is not feasible to transport outside the country in an independent country. That was feasible during British India because they have vast territory. So that's not feasible. That too they have taken it away only in 1950s, particularly 1956. Now let us deal what is sedition. Let us understand what is sedition. What is amounting to sedition? 124A, it says that whoever by words, by spoken or written or visible representation, signs or otherwise. The term otherwise may include even electronic, digital means, cartoon, other things also. Through the aforestated means, if you are creating hatred, ill will, contempt, even disaffection. Please remember, even the term disaffection was not originally there, but again it has been it was added later on. Disaffection towards the government established by law. That's also very, very important. Then if you do those things, then it may amounting to sedition. There are 3 explanations. It also makes it very clear that mere expressing comments, however it is strong, violent, using the violent language against the government for the purposes of changing the policies lawfully without inciting violence, it's not at all sedition. Any administrative measures, for that matter, changing any administrative measures, policies, all these things will not amount to sedition. When you are demanding change for the administrative measures, which you believe is incorrect, when you are demanding any policy measures, when you believe it is not correct or unconstitutional, illegal, you have the right. These are all protected within this IPC itself. But unfortunately, these letters of the law, the spirit of the law is not at all respected. People simply slam sedition charges not only under section 124A, sometimes they booked under particularly the journalists, lawyers, active lawyers, social spirited citizens or public spirited citizens, they are all booked under normally under section 124A, 153A and 505, something like that. The content of the subject matter of 153A, we will take it up in a separate video. Now we will come back to the constitutionality. The punishment, that also you should understand. The punishment, there is a huge variation. So it is from life imprisonment to 3 years. and penalty, or it can be done with mere penalty. So there are three options. You can impose punishment, life imprisonment plus penalty, or 3 years with penalty, or you can simply put them on penalty. But it is cognizable, non-bailable. This is also very important. Above all, it is compoundable. That is a different matter. So we will explain it to you a little later. Now, why we need to discuss about this law relating to sedition? What is the problem? Sir, you say it is compoundable. Then what is the problem? If the state and person agrees, the person can be relieved. But why we are discussing it today? This is a very important question. It's not I am telling you. The National Crime Record Bureau says this. Many critics are opining that after 2014, when this NDA government, particularly the government headed by this present dispensation, Sri Modi ji has taken power at the center, the sedition charges have taken a huge proportion. The cases are filed almost 80 to 90%. There is a quantum jump. Forget about the conviction. Conviction always will come very later stage, and many of them will result into acquittal only. But till then, these people have to undergo lot of trauma, thereby you are crushing the throat of those who are raising the voice against the government. This is very important. So, how to overcome this? We have discussed the problem. This is a problem. And you would have seen that these journalists, particularly in the COVID movement, when people are criticizing the mismanagement of disasters or malmanagement of disasters or non-management of disaster or failure in managing the disaster arising out of COVID, all these people are treated as anti-nationals, and they are all booked under this sedition and other draconian provisions, particularly under unlawful prevention activities, UAPA, all these things. The UAPA, we will discuss it a little later in some other video. So what is the remedy? This problem has assumed importance because of two important cases. One, this Andhra Pradesh Telugu channel case. There are two TV channels against whom the sedition charges have been filed, including an MP has been arrested for voicing concern against this management of mismanagement of disasters by the Andhra Pradesh government, YSR government, Jagan Mohan Reddy government. That's very unfortunate. And again, there is another journalist called Vinod, against whom the BJP government has filed an FIR, filed sedition charges. After a long time, he has been acquitted by the Supreme Court. There are two benches. Vinod case has been heard by Justice U. Lalit and Vinit Charan, Justice. And this Telugu channel case have been heard by our most beloved judge, Dr. D.Y. Chandrachud ji, and Ravindra Bhatt, and one more judge. I don't remember his name immediately. This 3-member division bench has come out with categorical things that they said the time has come to define the law. Please remember, Justice Chandrachud is known for decriminalizing adultery, decriminalizing 377, okay, all these things. So the entire nation expects him that he should do such a similar exercise in decriminalizing this sedition if possible. Otherwise, he has to give huge safeguards. Now, people are arguing there is one more landmark case called Kedarnath Singh case in 1962, way back. The Supreme Court has made it very categorically clear, unless there is any violence is the consequences of the speech or writing, it will not amount into sedition. But today, mere utterances of words is being treated as sedition, particularly when it is against the government. Again, there is one more case you all should know. When Madam Jayalalitha was the Chief Minister, there is a singer who has made a song against Madam. His name is, I think, Govardhan, something like that. He made a song against her. Just he sang a song against her. He was booked under sedition and treason and all other provisions. The court said mere speaking about the chief minister is not amounting to against the government and it is not anti-national. The courts have made it very clear, but still people are languishing, people are put to agony, sufferings. So that's why there is a huge demand to scrap this particular law is concerned. And now, if the law is not scrapped, what is the way forward? We should understand this. And interestingly or unfortunately, in Vinod Dua's case, there was a prayer requesting the Supreme Court to direct the central government or the appropriate government to constitute a committee. Okay. To clear FIR before it is being filed. The mandatory approval of the committee has to be sought. But the Supreme Court unfortunately has laid down such a request or prayer. They said it is outside the ambit of law. The Supreme Court doesn't want to do that. Now, so what we are demanding or what we are humbly submitting to this Honorable Supreme Court, to judges like Chandrachud, since he seized up this matter, if we are not able to scrap this law, if you believe it is genuinely required, the law should stay on, you can mitigate certain things. At least some protection shall be, some safeguards have to be given to the quote-unquote so-called accused. The matter brought before the magistrate, if the magistrate has the expertise, he himself should go through the content, and if he believes that it is not amounting to sedition as per the guidelines laid down by the Honorable Supreme Court in Kedarnath Singh case, immediately he shall order for the release on bail. That's very important. Unless this is done at the very mere production stage itself, otherwise this anguish and agony, it will keep on going endlessly. It will suppress the voice of the citizens. It will result into the grave violation of fundamental rights, including freedom of expression, privacy and other valuable fundamental rights, which is non-derogable, even in the times of emergency. I'm sorry, it is derogable, of course, but the right to life is not derogable during emergency. So, such a safeguard has to be given, such a direction has to be given the magistrates. If the magistrate believes that he doesn't have the expertise, then there may be a board like Juvenile Justice Board. You have board for many things. So there shall be a board. That board unanimously should say that yes, it is amounting to sedition, prima facie. Then only his custody, judicial custody or police custody, whatever it is, then only the person has to be remanded. Otherwise, he has to be released immediately on bail. This will solve many of the problems. We hope such good day comes sooner rather than later. God bless you all. Jai Hind.